Good morning.
Morning.
Okay. Well, I guess we'll start off with a little bit about us. So let's see, technically. Oh, there we go.
Okay, there you go.
Take it away, Ellen.
I'm Ellen Fawl, and I'm an attorney. And actually, my practice focuses on family law, probate, guardianships, and conservatorships. Prior to my current practice area, I practiced financial elder abuse litigation and trust and probate litigation. Um, what inspired me for law school and for this presentation was I've been active in animal rescue for 20 years, and I actually was an Amazon and cockatoo foster for Mickaboo for several years. I just want to point out something. It, I don't mind being referred to as an expert here, but in the legal terms, being calling ourselves an expert without certain credentials would not be good. So we are not, I don't have the credentials to call myself an expert legally in pet trusts. So I'll move it on to Alyssa.
Yeah. Likewise, I'm not technically an expert, but a little bit about me. So I do have my own firm here in Sacramento. Although thankfully with technology, I have clients that are all over Northern California and some in Southern California. I do, estate planning, trust and estate administration, and really any probate related needs. So any types of matters that might be pending in the probate court. I did go to school at UC San Diego, and I got my law degree from McGeorge, which is in Sacramento. It's a branch of UOP. And when I was in San Diego, I actually was a frequent supporter of a local bird sanctuary out there. And it really highlighted to me the importance of proper planning and just kind of seeing what happens to our feathered friends and their mental state, when they are surrendered or, something catastrophic happens to their person. And so, as far as on the estate planning side, I've really started to focus in on that and just make sure that depending on the client's need, that you're able to put in the proper planning for them and for their animals. And then I also do practice a lot in the areas kind of surrounding aging. So I do help ACC Senior Services, which is a local Sacramento care center, and they do provide services to seniors in the community. And so I do a lot of webinars for them related to estate planning. So yeah, I'm really excited to be here today. So thanks for having me. So kind of just to start off, to begin with, I wanted to cover, what do I actually mean by estate planning? I think a lot of people might think about financial planning, legal documents, and it kind of does encapsulate all of that. But a lot of people are probably doing some form of estate planning and they don't even really realize that they're doing it or what the possible repercussions are of the type of planning that they're doing. So pretty common types of estate planning would be beneficiary designations for different types of accounts, like your bank accounts or retirement accounts, so that upon your passing, you've already designated a specific individual to receive funds. In the case of like a retirement account, and if you were to name someone as a beneficiary, if it was like your 401k, for example, then the provider would end up just giving all of that money over to your designated beneficiary. And there's really no control that you have over what happens to that money once it goes out to the beneficiary. There's a lot of different considerations to make when you're thinking about who to name as a beneficiary, and maybe that is the most appropriate avenue for you for planning. But that's generally going to be one really common way that people do some planning. Another method is taking title to property. So whether that's jointly owning bank accounts with other individuals or jointly owning real estate with someone else, the way that you've taken title really will affect what happens to your ownership of that property upon your passing, or if you become incapacitated. I think a lot of people don't realize that it is very important when you take title with someone else, what the effects are on your ownership of those assets. And then really what we're going to dive into a little bit more specifically today is in the realm of legal documents. So, I'll be covering from a very high level, what a revocable living trust is, covering a little bit about, last will and testament, durable power of attorney for finances, and advanced healthcare directive, all of which are very important estate planning documents and really give you a certain level of control over what happens if you do become incapacitated or after you've passed away. As far as who is estate planning appropriate for, like I mentioned in the previous slide, most people are probably already doing some form of estate planning. But when it comes to the legal documents, at a very minimum, every adult should at least have a durable power of attorney for finances and an advanced healthcare directive. And the reason for that is because if you do ever become incapacitated at any point, whether it's a temporary incapacity or permanent incapacity, it's really important that you've already designated an agent or a specific person who you give authority to make financial decisions for you and medical decisions for you. Because if you don't have someone designated, then typically the default is that someone has to go to court to be appointed for you. And as Ellen is very well aware in the conservatorship realm, and I don't know if any viewers are familiar with Britney Spears, there's situations that'll come up where it can be very invasive if you don't have somebody you've already chosen or the proper legal documents in place, and it can be very public and very expensive in the absence of those documents. And then really, as far as a living trust, that's going to be most appropriate for people whose beneficiaries are minors, have special needs, aren't really very good at managing money, or those who have estates worth over a very specific number in California, which is $166,250 in value, or if you have real estate, that's going to be pretty much enough to push you into needing a trust. And then, of course, in the context of our discussion here, a living trust is going to be really important if you do have a pet that you want to leave very specific instructions for. And so a trust is going to be the best mechanism for making sure that you have control over what happens and how money is used for your pets. One of the biggest questions I think I always get is, what's the difference between a will and a living trust? Because I think most people are most familiar with the term last will and testament, right? You think, okay, as long as I have a will and I've designated who's my executor is and who my beneficiaries are, that upon my passing, my attorney or a trusted friend, or maybe the executor that you designated, they gather everybody up and they do a reading of the will, and then things are just kind of passed out. And that's not necessarily the case. A trust and a will are similar in the sense that you do get to name who the person is who will be managing your affairs upon your passing. And it also allows you to identify who your beneficiaries will be upon your passing. But the primary differences between those two documents is that with a will, it will most likely require probate court action in order to administer that will. Because in California, the probate court is the only entity with the authority to oversee the administration of a will, particularly in cases, like I mentioned before, where you have assets worth over $166,250 in value, or if you have any real estate. So that's something to consider, is that if you only have a will and not a trust, you're likely looking at a probate court proceeding if you fall into either of those financial categories. Whereas with the trust, it's something that hopefully, if you've put it together correctly, does not require any probate court action, and also hoping that nobody tries to fight or contest the trust, should be able to be administered privately. And so, if you've ever had to deal with the probate court process before, it's very public. Anybody can tune in. And in this case, in this day and age with Zoom, most courts are having hearings via Zoom. So everything is very public and anyone can see what's going on with your estate. Whereas with the trust, it is a privately administered document and can be limited to the beneficiaries or heirs that you have specifically designated. And the other key difference is, when they become effective. So a last will and testament only becomes effective upon your passing, whereas a revocable living trust is a living document. I always tell my clients, treat the trust's date of execution as if it's the trust's birth date. And from there, it actually starts working for you during your lifetime. And something we'll touch on later as it relates to our feathered friends or any of our pets, that can be really helpful if we have some very specific instructions already laid out that'll be effective during your lifetime in the event you ever become incapacitated. It also is very different in the amount of time needed to administer either a will or a trust. When it comes to a will, whenever you're dealing with the probate court, there's a lot of red tape and a lot of requirements that have to be met. And so usually I estimate for clients, if they do have to go through probate, that it'll probably be about a year to 2 years minimum before your beneficiaries receive the assets that you designated to them. So if you have, let's say you did designate money in your will towards the care of your pet, unfortunately, that money is locked up until you can get that final court order authorizing that the funds be distributed and ultimately go to the designated beneficiaries. So there can be quite a bit of delay and might end up actually running counter to what your intent was when you did set up your will. Whereas with the trust, again, it's as far as the time needed to administer, it can happen fairly quickly, again, assuming that no parties are fighting. There's usually somewhere between a 4 and 6 month time frame in which beneficiaries can start receiving their distributions. Of course, that all depends on the situation, classic attorney's response, right? It all just depends. But on average, that's going to be a more common scenario, is being able to do it much quicker with a trust than if you were dealing with the court system. And then, of course, cost, right? Whenever you're dealing with the courts, it's very, very expensive. I'm not going to go into too much detail about how fees are calculated, but on average, I usually give people the example of, let's say you were to pass away and you left behind a house that's worth $300,000. Based on the court's calculation, the minimum attorney's fees on a probate for something like that is about $9,000, and that would be just your attorney's fees, not including also your executor's fees, because they're entitled to the exact same fee. And so just to deal with the administration of a will, if you had a piece of real estate worth, for example, $300,000, you're looking at possibly $18,000 in just attorney's fees, plus about year to 2 years to get that done. And that doesn't include any out-of-pocket costs as well, usually about $2,000 or so in out-of-pocket costs to third parties. Not to say that a trust administration is going to be wildly cheaper than that, but it can be, depending on, again, if all the parties are in agreement, then attorney involvement can be minimal. And as long as everything is set up correctly and the instructions are really clear, then hopefully the administration can go quickly and smoothly and the cost is much lower. If you have any other questions, we can talk about those at the end. I did do a webinar recently with ACC Senior Services, and so we have a link to that if you want a little bit more of the nitty-gritty of how exactly a trust functions and what all the different documents are as well. All right. Ellen, take it away.
A little bit of pet history and why pet trusts and gifts have not been valid in history. So animals are considered personal property in the United States. So they can't hold title to property. So you can't leave them your house, your car, your bank account, your money, just by saying, I give this to my pet. So an old example, 1968, Chester Quinn was a close friend and companion of Miss Russell, and lived with her generally, and Roxy was her dog. So her will stated, I leave everything I own, real and personable, to Chester H. Quinn and Roxy Russell. Well, the first thing the court had to do was to find out who Roxy Russell was. I'm going to flip to the next slide. I think I've got that in there. And what the court, and they went through that. And then what the court said is, as the dog cannot be a beneficiary under a will, the attempted gift was void. So yeah, so as I noted here, fortunately, Roxy Russell passed away before the woman died, so that the dog didn't suffer, but the nasty niece got all the money. The lady had actually stated in her will that she did not want her niece to have any of the money, but because of the way it was set up, then the niece ended up getting it. So next one, okay, so then there's certain limits, and this is a very famous case from San Francisco. Mary Murphy was discovered dead in her apartment, and Sido was taken to the SPCA, and the will actually directed that her dog be put to death because she was afraid it would fall into uncaring hands. So there was a big lawsuit, lots of media attention on a national basis, and the legislature took the unusual step of passing a bill providing, in essence, that the dog couldn't be put down. But on its own, the court held that it's against public policy to have those kinds of terms in a will. So prior to current pet trusts, a pet trust, quote unquote, they were considered honorary. So you said, I want my trustee to do this, but he was on his honor as to whether he would do it. And as I have seen, and probably many of you, if you volunteer with Mickaboo, you've seen that that honor doesn't go very far when there's money and pets involved in many cases. And they can mainly just dispose of the pet at their discretion. So, in the state of Holtzman, this is not a good story. A woman gave $25,000 to her friend for the care for the 2 Irish setters, and the family came in. They euthanized the dogs 2 days later, and they said it created an honorary trust, and she didn't have to carry out the wishes. She was just on her honor to do it, and the family did not. So there was no enforcement mechanism other than the hope that the decedent's wishes are met. So with that, let's have some talk about what current statutes are. I'm going to turn this back to Alyssa.
Yeah, so, Ellen covered the history. Common law really was not very favorable to pets. And so in about 2008, the California did pass a statute and it made this statute a little bit stricter. It was a statute already existing, but they did make it a little bit stricter, which is Probate Code Section 15212. Try not to bore you too much with the specific details of a statute, because this isn't a legal class or anything like that. But, it's important in this context because it did provide that a trust created for the care of an animal is lawful, non-charitable, and fully enforceable. And generally speaking, that trust can continue to exist after your passing, so long as no animal living on the date remains alive. So basically, the trust can be established for any then living animals and then would eventually terminate upon that then living animal's passing. There are some obligations that the trustee will have to observe, and we'll talk a little bit about who a trustee is in a bit. But basically, whoever the person is who's in charge, right, that you leave in charge of managing that money, any of the trust principal and income has to be used solely for the care of the designated animal and cannot be converted for the trustee's use or any other purpose. So that trustee is really acting in a fiduciary capacity, such that they are not personally entitled to that money, and the pet is actually the designated beneficiary. And then eventually, once that trust terminates, the trustee has to distribute any of the remaining funds that are in that trust, either as directed in the trust agreement, which is going to be a very important piece of planning. If there's any residuary beneficiaries in a settler's will, if that's applicable, or to their heirs, whoever their closest living heirs at law are. And there's also some really interesting explicit trust enforcement provisions. So what's really interesting about this probate code section and how strict it became is that we really are treating pets as if they are people, right? Even though the common law and even though animals generally are treated as personal property, in the context of a properly drafted pet trust, that pet is going to receive lots of different rights that they otherwise wouldn't have if you didn't have a proper pet trust. And so let's say that for some reason the position of the trustee is vacant. A court can actually appoint a successor trustee, and that trustee has to prove to the court in that filing why they're appropriate and that they can actually qualify possibly to be bonded for the amount of money that's in the trust, so that just in case something happens, that the trust can be made whole. Also, there is another very interesting enforcement provision in that probate code section that says any person named in the trust document or beneficiary of the trust, any person interested in the welfare of the designated animal, or any nonprofit charitable organization that has its principal activity in the care of animals may enforce your intended use of the principal and income allocated to that trust by petitioning a court regarding the trust's internal affairs. And so that's basically just ensuring that what you've put down to paper is actually going to be enforced. Now, the trustee, upon request, should provide accountings to beneficiaries who would inherit if the designated animal was deceased, or to nonprofit charitable animal organizations if the allocated property exceeds $40,000. So really all of these different provisions that are incorporated into the probate code section are meant to make sure that the pet trust is actually enforced and that it's not just a fancy term for an honorary trust, right? So that in practice, there's actually some teeth to it. Now, the next question I usually get from folks is, how does a pet trust actually function, right? So typically what's going to happen is someone's going to create their own revocable living trust, again, that becomes effective upon the date that they execute that trust. And then eventually upon your passing, we would have already created very specific instructions in that trust for the pet trust. And what happens is, whatever we've allocated to that pet trust really functions as a subtrust. So it almost like kind of branches out from your main trust and becomes its own separate trust. And it's going to be administered according to the pet trust provisions. So what the pet trustee does from there is they would actually fund the pet trust with the designated funds. They establish a separate account for the pet trust. They have to get a separate tax ID number to do that. And they would, basically just use the funds in that account to care for the pet for the rest of their lifetime, according to the pet trust instructions, for the rest of the pet's lifetime, I should say. And some considerations whenever we're creating a pet trust, as an estate planning attorney, some of these are going to be the main things that I'm going to be talking about with my clients. One, of course, is identifying the pet. So we want to see if it's for a specific pet or whether you want to open it up and say any pet that's living or pets that are living at the time of my passing. A little bit of caution there, though, when we leave it very open to any pet living at the time of my death, we want to make sure, too, that we possibly have somebody available in the document that is going to properly identify what pets actually belong to you at the time of your passing. So that, let's say you have your designated caretaker come in later and that caretaker has pets of their own. We don't want them necessarily piggybacking off of your trust and trying to claim that their pets are in fact your pets and entitled to use of the funds. So it's important to be able to properly identify what the pet or who the pet would be that's going to be the beneficiary. Pet trustees are going to be really important as well. So the pet trustee, like I identified before, is going to be the fiduciary that is basically handling the money that you've allocated or whatever assets you've allocated to the pet trust. And they're in charge of keeping good track of records, making sure that the pet is going to be receiving whatever needs or being covered for whatever their needs are. In some cases, the pet trustee needs to work in tandem with the pet caretaker, if they're different individuals, to try to make sure that based on the life expectancy of the pet, that there is a proper budget in place for the pet's needs for the rest of that pet's lifetime. And then just collaborating with the caretaker, again, if they're different individuals. Some people, as an additional level of enforcement, separate from what the statute provides for, may also decide to appoint a pet enforcer. So that can be another neutral third party who has the ability to request status updates about the pet's care, what their well-being is like at the time, and the ability to look in and see from an accounting perspective, what's been happening and how the trustee's been actually managing the money. Another provision, of course, that we're going to have to always talk about is what is the proper amount or assets that we're actually going to allocate to the pet trust. Many different considerations that we take into account are, what is the possible life expectancy of the anticipated pet that's going to be the beneficiary, whether that type of pet has any known or possibly foreseeable health conditions in the future, and whether we need to plan for that. Kind of averaging out what that pet's needs are currently. And so considering the amount per year that you spend on average, and kind of separating and multiplying that out for the number of years that the pet could live for. We want to really make sure that we're calculating it to a reasonable degree, because as has happened in the past, some heirs who might be listed later might not necessarily be really thrilled if they see that a few $1,000,000 has been allocated specifically to the care of a pet, and they might try to challenge that. So to a certain degree, we also want to be very reasonable in the amount of funds that we allocate to minimize the possibility of any litigation in the future from possible disgruntled remainder beneficiaries or other family members. And then we also want to identify what happens to the remaining funds after a pet passes away, because it is possible that either your pet is not living anymore at the time of your passing, or that the pet does pass away before the full fund has been fully used up by the time of their death. And so we want to identify a proper beneficiary that and something Ellen and I were talking about beforehand is maybe identifying a beneficiary that is not someone who is possibly in control of the pet's fate, meaning that there's someone who's not necessarily chomping at the bit for the pet to pass away before they can receive whatever funds are remaining. And so there's a lot of different considerations that we want to think about as far as who that remainder beneficiary could be. All right.
All right. So something to think about, and this comes again from my years of doing animal rescue. This is a question from Pure Veg Plus Cat Rescue. What arrangements are in place for your pets if you pass away? Well, these are the usual answers. My family wants them. Next. But the reality is, but next slide.
Oh, sorry.
Yeah. So the reality is, as soon as the person passes away, the family calls us to take the animal back, even if they promised us that they would take it. We get a call from an animal shelter that the owner died and the family dropped the cat off, or worse, the cat's turned out and it was picked up, dropped off stray, injured, and we have to come get it. So go ahead, next slide. So the reason may be, why does your family maybe not want to take them? Allergies, lifestyle, or they really don't like your pet. And then, as Alyssa was saying, expenses. Next slide. I actually solicited some, this information on Facebook, and, exam, toenail, beak, and feather trims. Do you do it yourself? But can your niece? What about the toys they shred, the food they throw over the floor? Those things get expensive. I placed a wonderful Amazon to the best family ever, and I found out she recently was diagnosed with ovarian cancer. The costs were $3,000, I think, to get the diagnosis and the chemo. These wonderful people will be paying $300 a month at minimum for the rest of her life to keep for the upkeep and the meds. And family members may not have the funds to do this. They just might not have the funds. So kind of thinking ahead, as Liz was saying, planning what you think might be a reasonable amount, and then some. And then next slide. Go ahead.
Yeah. So we wanted to come up with a couple of examples, right? So in this hypothetical, Mary passes away and leaves behind a conure named Kiwi, who's 5 years old. She sets up a pet trust. So she actually does some planning ahead of time, naming her daughter Sarah as the pet trustee, but Sarah doesn't like Kiwi, right? And Mary didn't name an alternate pet trustee. Mary allocates $5,000 to the pet trust with instructions that the money be used for Kiwi for the rest of his life. And then upon his death, Sarah receives any money left over. But in this scenario, when Mary passes away, Sarah, because she A, doesn't like Kiwi, and B, is also the remainder beneficiary, just surrenders Kiwi to the local animal shelter and takes the rest of the money for herself. If we look at the pet enforcement provisions from that previous statute that I mentioned, because the amount is so low, no kind of animal welfare organization has the ability to demand any accounting of Sarah. And so really, she's the only one holding herself accountable for making sure that that money was actually appropriately used for Kiwi. So how could this have been set up better? This is just one possible scenario of how it could have been set up better, but thinking of the exact same facts, If Mary were to pass away, left behind Kiwi, who's 5 years old, she set up a pet trust naming Sarah as pet trustee. But if Sarah can't act as the trustee, she actually names a professional fiduciary as the alternate successor. Now, really quickly, a professional fiduciary is basically a neutral third party who does this as their entire career. They step in to a fiduciary capacity to administer trusts like this, or any other type of living trust or other types of financial management for others, and as a neutral third party. And in this case, Mary allocates $50,000 to the pet trust with instructions that the money be used for Kiwi for the rest of his life. Given that conures typically have a life expectancy of about 20 to 25 years, this is probably a sufficient amount to properly ensure that he remains happy and healthy for the rest of his lifetime, assuming that there's no, big catastrophic health diagnoses for him in the future. And then after his death, the money remaining in the pet trust, if any, is supposed to go to a designated charity. That designated charity can then request accountings from the trustee. So let's say Sarah does decide to stay on as the pet trustee, she would be held accountable to the charity, who would be entitled to information of them being named as the residuary beneficiary upon Kiwi's passing, and they could keep her accountable. So this is just a simple way that with planning, we can tweak things a little bit and maybe have a more detailed conversation about what the possible pitfalls were with Mary's first setup of a pet trust, and how we could tweak it a little bit so that, it's not necessarily always going to be foolproof, but it does provide a little bit more of a stable situation for Kiwi, and that he can just be happy for the rest of his lifetime as the goal.
So one thing that I've seen several times, been involved with, and I think Alyssa will agree, you get this question, I want my pets to stay where they are. I want to give my animals the home, or I want them to live in the home. So I'm going to fly through these so we can get to the meat of this. But this case, a woman provided that her daughter could use the trust property, but the other beneficiaries and the cats were going to stay there in the house until the last one died. The other beneficiaries wanted the money right away. They fought her. Go ahead and click to the next slide. I just want to move through these. So anyway, in that one, the woman prevailed and got to stay in the house. This is another one that Purebred Plus was a remainder beneficiary in. So the trust instrument provided $300,000 for the continued maintenance of the cats, but the lady expressed her desire that her friend or roommate have the right to live in our condo rent-free during the cat's lives and for a 2-year period thereafter. And this is where it was a problem because the other beneficiaries wanted the money, and she had essentially created an honorary trust, or a situation where it wasn't locked in for the house. And so in this case, as I said, what could possibly go wrong? I mean, like everything, because it's not, everybody wants their money. It wasn't well laid out. And I think this case is still in litigation. It was 2019, 2 years later. I'm pretty sure that this is still in litigation. I'm willing to bet that $300,000 is going to be chewed up in attorney's fees. So go ahead.
Yeah, so just one thing that I would talk with clients or caution clients about is just beware leaving real property or any sort of real estate to or with a right to reside is what we call it, or possibly a life estate to a specific person with precatory language. And precatory is really like that honorary language where you say, I desire this, but it doesn't actually require that the trustee or the beneficiary act in a particular way. If you have that precatory language about your pets being taken care of by the person residing in the property, if there ever was a conflict in the future, the person will likely be prioritized as a beneficiary over the pets if they're eager to cash out. It's thankfully with the statutes that I mentioned before that we've covered, there are some ways that the pet's interests can be represented by either an organization or by an enforcer, a pet enforcer. But it's very difficult when you're dealing with real estate that's possibly real estate and possibly with a not very liquid estate. And there are remainder beneficiaries that are possibly individuals and maybe not a charity, and who may be eager to, like Ellen said, cash out. And so, it's really, we have to be really careful about how we're planning on what to allocate to a trust, just because the law is so unsettled. So we can't necessarily guarantee exactly how it's going to come out, but you probably also don't want there to be litigation because it's not very clear, as far as whose rights are going to be prioritized in that situation.
So concerns for our animal companions, they shouldn't be limited to after our death. And as we age, changes occur, and that makes it more difficult for us to care for the companions. And for my mother, for example, her pets are her life. That's what she has. So as long as we can keep them in the home and keep them healthy and safe, we want to be able to do that. So go ahead. This was a default wording. This was actually almost put into our powers of attorney when we made our estate plan. At the highlighted area says we want to take care of our cats, but if it's too expensive, my power of attorney can just dispose of the animal. I just hated that wording in a humane fashion. How do you dispose in a humane fashion? So go ahead and click the next slide. And what we did is it's the tiniest little tweak. You want to be an advocate for your animal companions, and we changed this to say to rehome the animal to a trusted family member, or by using a reputable 501c3 or no-kill shelter. And then just right there, no way are you going to euthanize my pet because it's too expensive. So we just, and I think Alyssa can provide better guidance on that.
Yeah, and so it's really important, right? You always have to be careful of the dreaded boilerplate language. Because pets and animals generally are considered personal property and are not prioritized under the law in many ways, as opposed to human life. It is really important that we have specific instructions in place that are much more humane, much kinder to our pets. And as Ellen said, we want to make sure that there's no specific language in there about euthanizing our pets or disposing of our pets if we can't take care of them. During your lifetime, all of your money is your money and you get to do with it as you wish. And so a really important piece of doing your powers of attorney and something like a trust is that you get to dictate what happens and how your agent or whoever you've designated to be in charge, how they should use the money for your benefit, but also for the benefit of your pets. Now, it is a little bit of a war that they have, right? In the sense that they need to make sure that you are properly taken care of too. But I think that what Ellen did is a really nice balance, striking a really nice balance in customizing the language so that the pet is taken care of, but also if it's just not feasible financially to both take care of you fully and your pet, that there be a humane alternative and a kind alternative for that pet.
So, and I think Alyssa will agree that generally a power of attorney is going to contain, because we had a question on, can I set something up, in case I become temporarily incapacitated, and that sometimes that's contained in the durable power of attorney. That'll have a nomination of a conservator, determination, how you determine whether you're incapacitated and what happens if you regain capacity. Alyssa, do you agree with this?
Yeah, so very commonly, right, whenever we have that power of attorney in place, there's going to be some sort of triggering event, right, where we're identifying when that agent is actually coming in, stepping into your shoes, and basically, for all intents and purposes, acting as you during your lifetime to manage any of your finances that may not otherwise be managed by the trust. And so pretty commonly, a determination of incapacity is going to be by at least one physician, if not two physicians, before that agent has the authority to step in. And whichever method they use to determine your incapacity, you would use that same method to determine whether you regain your capacity. So just because you do become incapacitated, it doesn't mean that your authority to manage your own affairs goes away for the rest of your lifetime. You can really regain control and take the reins again, depending on the terms that we include in your documents.
As she mentioned earlier, don't let Free Brittany frighten you. It's a necessary area of law, and when properly done, it can protect you and your pets as you age. And I believe, Alyssa, you did express that some of this pre-planning can be handled in the trust, not just a durable attorney, right?
Yeah, and really, when we're talking about conservatorships, that's going to be a conservatorship. If our viewers are not aware, is basically where somebody has to go to court, ask to be formally appointed, either to manage someone's person, so meaning medical decisions, where they live, any other well-being decisions, or their estate, which is going to be management of any and all property and other financial issues that might be related to that individual. And so, you know, a conservatorship is kind of your arena of last resort. So hopefully you don't have to deal with the probate court in establishing a conservatorship because you've done some proper planning ahead of time. But I would say that in both a living trust and in your powers of attorney, you can specifically make sure that if you do become incapacitated, almost kind of like treating your pet as if they were a dependent, and extending your current use of funds for their benefit, and continue basically an extension and a continuation of that care and the use of resources and funds for the pet in the event of your incapacity. Now, when it comes to a conservatorship, though, you know, normally, again, you really would be dealing with this if you didn't have estate planning documents that are going to be appropriate, or if you do have current estate planning documents and for some reason a conservatorship is required, you know, your power of attorney is likely going to be revoked in that situation. An example of that, and I don't want to get too far in the weeds, but an example of that would be if the person that you've designated as your agent is being, you know, engaging in some sort of abuse, which I know Ellen will be discussing in a little bit. But yeah, if they're engaging in some sort of abuse and are not the appropriate person, and maybe you don't have a backup in place, then the power of attorney might get overridden, in which case the living trust can be a good document available to specify how funds are used. And again, we just want really specific instructions so that it's really clear that when the trustee does step in, even if you do have a conservatorship, for example, of the person to take care of you, if you can't manage things on your own, that there is no conservatorship of the estate necessary, so that the trust instructions can be, you know, what controls the use and management of your funds. Because really, from a liability perspective, whenever we have someone who's in charge of managing someone else's money, default rules, again, are always going to prioritize you, the person, over any of your pets. And so unless you have very specific instructions in place, unfortunately, pets often fall to the wayside and are surrendered in conservatorship contexts, or, you know, let loose to try to fend for themselves, unfortunately. And, you know, there's not a lot of advocacy for those pets in that situation. So yeah, sorry, very long-winded way of saying that, yes, a trust can be the more appropriate way of making sure you have specific instructions in place. But again, if you don't have any of those instructions and you have no estate planning documents and you end up in conservatorship or in a conservatorship, then unfortunately your pets are not going to really have any priority or have much of a say of any, if anything, in that context.
I think we should end it here. I think that if we get into the weeds in financial elder abuse, we're not going to have time to take people's questions specific to this. So with that in mind, should we open it up for some questions? You want to back that slide up a couple? And
oh, yeah.
Yeah, I'm just, yeah.
So, oh, here, I'll go to the
yeah, oh yeah,
this
is a disclaimer and yeah. So if you have questions, you can contact either of us, as we've got our contact information up there. Alyssa, did you want to see anything?
Yeah, I'm looking at the chat. I don't see any questions so far, but yeah, if anybody wants to add it.
Oh, there we go. We've got one from Jeff, if you see that there, Alyssa and Ellen.
Oh.
So if you adopt a Mickaboo rescue, you agree to return the bird to Mickaboo if you are no longer able to care for the bird. So for a Mickaboo rescue, is it needed to have a pet trust or just instructions to return the bird to Mickaboo?
That's interesting. So earlier on in the presentation, I mentioned that in some cases, the trustee, the pet trustee, can be a different individual from the actual caretaker. So if you, let's say, allocate the money, right? Like, let's go back to the Mary situation. If Mary allocates $50,000 for the care of Kiwi, it doesn't necessarily mean that Sarah has to be the one to, Sarah, her daughter, has to be the one who's also the caretaker. So it's possible that if you adopt a Mickaboo rescue, that animal has a separate pet trust that's already in place for that pet's care, with a trustee managing the money for them. So even if that pet does get returned to Mickaboo and is then adopted by another person in the future, then the pet trust still follows that bird. And so that bird should still be able to retain its benefits through that trust.
Okay, we have another question from Linda Liebold.
Okay. Okay. Linda said, how do I designate Mickaboo as the trustee for a trust for my conure Wally? Oh, Wally. I love that name. Okay. So, I actually did talk to Pam about this. I know this is something that Mickaboo is still trying to figure out whether, they would be willing or able to step in formally as a trustee. Normally, as far as what the trustee is doing, they're really acting in a fiduciary capacity. And like I mentioned earlier, actively managing an account and making distributions and keeping track of assets. So it might be more appropriate to possibly name a neutral third party, like a professional fiduciary, to be the one to manage the funds. And then you could possibly work with Mickaboo for rehoming of the pet upon your passing, or for Wally upon your passing, if you don't have a particular caretaker that you have in mind.
Okay, and then we have another one from Kathy King, which says, if you don't have family or a trusted person to name to care for your bird, can you designate that the bird be turned into Mickaboo with a stipend to rehome them? The bird was not adopted through Mickaboo, so this is a normal run-of-the-mill, non-Mickaboo alumnus. And the question is, can they designate X dollars to come with the bird, as it were, into Mickaboo? And whenever I've had conversations with people, there's the question of, does the money stay with the bird after they're rehomed to a permanent person? Or does it stay with Mickaboo? There's all sorts of things I think that need to get laid out in that provision. If you could speak to that, Alyssa or Ellen.
I think this is really important because I am aware of certain SPCAs that you can leave your pets to the SPCA. They'll guarantee that while your pet is there, they do an exam and take care and feed it. But my understanding is that after they adopt a pet out, that money stays with the SPCA to be used for their purposes. So I think that a person really does need to know how they feel about that and how they want to handle that. Some people say, I just want my pet to have a home, and then this money can go to help other birds, or I really, really want this money to follow my pet.
Yeah, so I think maybe a good kind of midway point could be if they really want to ensure that the money follows the pet, but that the pet still, or that Mickaboo, for example, still has funds available to it for the continued care in the interim until the pet has been rehomed, that there are instructions in place that says that possibly somebody else is managing the money, but that those costs are covered through the rehoming, and the money follows the pet to wherever they are rehomed. So really it is a determination, though, like Ellen identified, whether the owner or the person who's creating the trust really does want that money to just be a little bit simpler and like a lump sum gift to Mickaboo for the purposes of rehoming, and then they're okay with any of those remaining funds staying with Mickaboo, or whether they want it to be a little bit more formal, complicated structure of the pet trust where it does follow the pet.
Okay. We've mentioned the term professional fiduciary a few times. Could one or both of you define again what a professional fiduciary is and where one would find such a person or entity? Yeah.
So, yeah, California is interesting because professional fiduciaries are not available as a resource in all states. But in California in particular, we have what are called California licensed professional fiduciaries. And they're essentially going to be a neutral third party who is licensed and bonded by the state of California, who would provide trustee services or who would provide, kind of in the context of more like senior, if there's any senior clients, things like basic bill pay or ongoing management of funds. So with a professional fiduciary, they're really going to be somebody who doesn't have any skin in the game, really, right? They are simply hired and appointed as the person to manage the funds and follow the instructions. And they will get paid for their time, right, to manage the funds. But if you just go, I'm trying to think of the website, but there is a professional fiduciary group. I think PFAC might be the PFAC might be the.
Yeah, it
What's
looks like
that?
Jeff has found it and posted it in chat. pfac-pro.org.
Oh, great.
Yeah.
Yeah, so PFAC is great because they actually list out fiduciaries that are in your area. So it's a good way to kind of filter through. And then a lot of fiduciaries are great because you can just interview them and see if they are the kind of person that you would that you would feel comfortable turning your funds over to first and foremost. And then it's good because you get a chance to talk to them ahead of time and ensure that they know what you want to have happen with those funds. So yeah, you can Google them. You can ask if you know anybody who has a fiduciary and whether they've had a good experience. But yeah, that's always a pretty good alternative, especially if you have family members who do not want to be the pet trustee or who do not want to manage funds generally for you.
Okay. Speaking of California specifically, and given that laws are different in different states, let's say someone creates a trust in California and then they move to a different state. Would they need to consider making a new trust?
Yeah, so answer to that is classic. It depends. Each state has its own probate laws. And so California trusts are created under the California Probate Code. Depending on what state you move to, the way that I draft my trust, and most trusts are drafted this way, is such that even if you do move to a different state, that the trust can still be administered in that state. But it's very important that if you do move, that you consult with an attorney, an estate planning attorney in that state, just to review the document and see if there are any laws that conflict with the California statute. Because again, as identified before, California statute is pretty strict and probably more strict than other states are when it comes to pets' rights. So it is important to see whether the possible move to another state might invalidate or possibly take a lot of the teeth out of the pet trust specifically. But the overall trust is going to still be valid. You may just want to update some of your terms to comport with that new state's laws.
Okay, so there again, California's leading the way. Love it. Okay.
They always say it starts in California and then the rest of the states possibly follow suit.
Yeah. So the next question has to do with the interaction of the trust and the subtrust, right? So the big trust, the living trust, and then the pet trust being the baby trust, as it were. So Linda Liebel writes, what role does the trustee of my estate, so that's the big trust, if I designate Mickaboo or some other party, as the pet trust trustee? What's the interaction there?
Yeah, so normally what'll happen after you pass away is the main trustee has to do what we call marshaling of the assets. So they identify what all the assets are that are going to be administered as part of the main trust to start. Once they have paid all of the final expenses, filed taxes, maybe sold any assets that might need to be sold, they would then allocate whatever has been specifically designated to the pet trust to that pet trust. So like I mentioned, then the subtrust kind of funnels off from and branches out from the main trust. And if you have a different pet trustee than you do a trustee for your main trust, the two of them would just need to collaborate to make sure that the handoff is smooth. So the main pet trustee doesn't necessarily continue, or I'm sorry, the main trustee does not necessarily continue to have any oversight after the funds have been allocated to the pet trustee. And then the pet trustee basically just continues on from that point to administer the trust.
Okay, so two follow-on questions to that point. One is from me because I, after my mom passed away, went through a lot of work to deal with her will, even though it was relatively easy because dad still survived and a lot of the assets, poured over. But still, a lot of work. And when you talk about the main trustee having to handle a certain amount of paperwork and then fund the pet trust, that feels to me like there might be some amount of time between
Possibly.
the two sets of actions.
Yeah, it is possible. Now, one good thing, depending on the, like, let's say, oh gosh, it's so hard. It really just depends. And I hate giving that answer, but it does depend on who the other beneficiaries are, because it's not uncommon with trusts for there to be a partial preliminary distribution. So even though there are a lot of these kind of smaller behind the scenes pieces that have to be dealt with before the full funding can happen to the pet trustee, it is important that, as Linda identified, kind of that crossover between the main trustee and the pet trustee, where the pet trustee can collaborate with the main trustee to ensure that some funds are at least allocated to bridge the gap between the time that the settlor passes away and the full distribution is made to the pet trust.
Right, because we wouldn't want the bird to have to wait a year before they get their next meal.
Exactly. The other hard part, now, we don't necessarily always want to put the pet trustee in this position, but pet trustees are always going to be entitled to reimbursement as well. So if for some reason there is a week delay, right, between when the person passes and the pet trustee receives any partial preliminary distribution, they can, pay for some needs for the pet and then immediately get reimbursed from the pet trust for those, as long as it was for the benefit of the pet too. Not saying that, there's no specific responsibility to the pet trustee to do that, but sometimes that happens as well.
Yep, got it there. Okay, follow-up question then from Linda on this point. She writes, in other words, a professional fiduciary, not the trustee of the main trust, or Mickaboo, might be the best one to administer the pet trust.
Possibly, yeah. Especially if you think that you don't have a family member or trusted friend who is interested or willing to be named as the pet trustee.
Okay. Let's see. Clarification request here. Is a pet trust a separate trust or is it incorporated in a regular revocable trust?
So it can be either. Most commonly, it's going to be a subtrust that is referenced within a regular revocable trust and then eventually gets distributed out to the pet trust upon your passing, with additional instructions, though, if you become incapacitated, so that the pet can still be cared for. Some people, though, they will do a standalone pet trust that they actually fund with assets during their lifetime, and they are the trustee of that pet trust, and then during their own lifetime, and then if they become incapacitated or pass away, they have an alternate pet trustee that's already designated. So it doesn't necessarily have to be this main trust, subtrust branch off. It can be its own standalone, but just be aware that if you are creating a separate standalone trust during your lifetime, there are possible additional administrative expenses for continuing to administer actively that trust during your lifetime.
Right, but it sounds like there might be some advantages there because if you've got a separate trust that already exists with its own assets, then we might not have to worry about the funding of it.
Correct. Yeah, then there's no delay.
Yeah, okay. Linda asks, would Mickaboo advise her as to the proper amount of dollars to put in trust for Wally? We can certainly help with the math. And we would probably also throw in a buffer in case of unanticipated major medical expenses like cancer and such like that.
Mm-hmm. And possibly, right, like the cost of insurance premium, if there's any medical insurance for the pet available in the future.
Okay.
All right, let's see.
Alrighty, another one here. If we have a current revocable trust, so somebody already has a living trust, how can we add a pet trust? And it sounds to me like someone might need to go back to their professional and have a small rewrite. What do you think,
Mhm.
guys?
Yeah, the good thing about a revocable trust is that it can typically be amended as many times as you want to during your lifetime. There's some restrictions to that depending on how the trust was originally created. But if you do go to an estate planning attorney, they can review the current provisions of your trust and then add in provisions for a pet trust upon your passing.
Okay.
I think there was
Gregory.
also a question from Gregory
Yeah, I
up
was
at the
just about
top.
to get there.
Okay.
Yeah. I said, would a potentially desirable win-win situation be if an organization like Mickaboo be designated the trustee for rehoming the bird and also providing a significant charitable contribution to the organization from the estate beyond the care of the bird while they have it?
Oh, so almost like a double distribution possibly. So one distribution allocated for the bird and one for the charity, I think is that.
Sounds like it, yeah.
Yeah. I mean, yeah, there's, it all depends on how much assets you want to allocate, but that's certainly one option.
Yep, and I will say that Mickaboo has been honored by being the beneficiary of some bequests from its supporters, and it's been just a wonderful thing for our
Mhm.
birds to receive such. I can personally say that we have been in financial situations over the last couple years where we might have had to declare a financial moratorium, i.e., not taken birds, but been able to sidestep that because of the bequests uh,
Mhm.
that we have received. So those are very much appreciated by those who want to help Mickaboo survive for the benefit of its many, many birds that need us.
Mhm.
Um,
Yeah.
let's see here. I don't know that. Oh, here. Colleen writes, this wasn't directly covered, but it is a good idea to share your plans with Mickaboo if you're updating your documentation, and Mickaboo will take an active role in caring for your bird. Advanced planning is good for everyone. And yes, planning in general is a great idea.
And that actually, Colleen brings up a good point, which we've kind of talked about a little bit as well, or touched on briefly throughout the presentation, which is anybody that you're planning on involving in a fiduciary or any sort of management position related to your pet, with the pet trust, or even generally with estate planning documents. It's a good idea to make them aware that you've designated them in that role and to talk to them ahead of time to make sure they're okay with it. So yeah, very important.
Right. I mean, to take one of your examples, you might designate in your will that, my Uncle Bob is going to get my, cockatoo and, X dollars without telling Uncle Bob. Um, and then after your passing, when Uncle Bob finds out about it, says, oh no, I'm allergic to, pet dander, this kind of thing. So you don't want that to happen to your feathered friend and then have potentially untoward circumstances after that.
Mhm. Yeah.
I want to step
And
in.
and as oh, go ahead.
I just want to make a point because this actual scenario, I tried to get the pleadings on this case and I just couldn't get them in time. But a pet rescue person I know was supposed to get money from an estate to care for the dogs. Of course, the family, didn't want her to have it. But I believe that she had to take court action to even get a copy of the trust. So they were hiding the trust from her, and this happened. So it's as long as the trust document provides that you can, you know, my opinion is if you got someone who's supposed to get the bird and some money, I think it'd be a good idea. But
Yeah, so they're not surprised at least, or can voice their objections ahead of time, and you can make different, better arrangements for your feathered companions or furry companions, right? Because this applies to both.
Right.
Patty says, I created joint ownership with the person who would care for the pet and a separate joint checking account for both of us. So while she's alive, clearly.
Mhm.
The person could run off the money could run off with the money or pet at any time, since the checking account currently exists. but obviously a very trusted person. So she's gone with an account ownership angle on it.
Yeah, that's just one form of estate planning that you've kind of already done. And as you've identified, the possible risk is when you have joint ownership with someone else, that other joint owner has just as much right to either run off with the money or with the pet as you would. And so that's a possible risk. The hard part whenever you do have joint ownership is untangling yourself from that joint ownership. And so if it's somebody, if they are a trusted person now and you maybe don't feel super comfortable with maintaining that joint ownership in the future, you might want to consider having a conversation with them now while things are good before, anything gets kind of messy if there are any conflicts later.
Right. I mean, joint ownership is obviously a construct that is often used between people and their partner or significant other. And I've heard a lot about this concept called divorces, where people who used to like each other don't anymore. And, having the pet sort of caught up in that kind of a conflict is never a pleasant thing for sure. Adding to the question, should I add my main trustee, in this case Linda's niece, to the account now to be used to disperse future funds for Wally's care?
So if the goal is for her to act in more of fiduciary capacity to use the money for Wally according to a pet trust, then the only time I would recommend putting her on as the main trustee to the account now is if you also want her to be a co-trustee with you right now. Otherwise, if you have a trust account, that's the only way you can get somebody else put on is as a co-trustee with you. If you changed the account so that it was like an individual account and you added her on, then it's joint ownership of that account. And upon your passing, she legally owns any remaining funds and it's not connected to the trust.
Yeah. I mean, mechanically, I remember, again, when my mom passed and Dad needed to get me onto his counts, it was a relatively easy process to present the death certificate as well as the legal documents to the bank. And obviously, every bank has their own process and, get my name on it because I was named as, one of the co-trustees at that point. So just have your legal documents with you for sure, which includes the death certificate, which can take a little bit of time to get.
Yeah, I think right now they're estimating about 10 to 14 business days now, just due to backups.
And COVID-19 and everything else.
Yeah.
I see, Louisa, that you have a question, but I see just a fragment of it. Sarah, can we unmute Louisa? It might be easier for her to just ask the question. Louisa.
I'm working on that.
Yeah.
Oh.
Yes, this is being recorded. You will be able to watch it ad nauseum. Or, it's not like it's, whatever. Yes, it is being recorded. You'll be able to watch it later. We will take a little bit of time to clean up any, video artifacts because Sarah's excellently picky that way. But we will post it for the world to see and we will announce it when that has been done. And we will also make the PowerPoint available if you want to email pr@mickaboo.org. We will shoot that out as soon as I get the cleaned up version from Ellen because she's noticed a couple typos that she wants to also clean up. And it is now 12:09. I'm looking for any last minute questions. Going once.
Hey Pam, this is Sarah. I think it's probably worth mentioning that whilst Mickaboo isn't a named trustee for any party at this point, and that's still an open question about whether or not that's something we could take on. We do have a list of people who have already reached out to us, as was suggested earlier, letting us know that they are planning to leave something to Mickaboo. in their estate, and also information about their birds, so that we have as much information as you can provide. So some people have done that to very, very fine amounts of detail, their birds' daily routines and what they like to eat and their favorite toys. And some people have just left more general information for us about exactly what kinds of birds they have and how old they are and who their vet is. And we have that all saved in a secure space. So in the event that something happened and we heard from that family's estate, then we would have that information ready to use.
Right. So to elaborate on what Sarah just mentioned and what's been raised before, if you would like to include Mickaboo in your planning, not only would it be appreciated if we have a copy of the legal document, but also some sense of what your bird would want to enjoy after you're gone and no longer able to care for him or her. And we will also work with you to make sure that the contact information that is available to your trustee is accurate, so that we can, be available to help as soon as possible and needed after your passing. So, send that information if you need to and want to. Happy to do that over at mail@mickaboo.org, mail@mickaboo.org. And, we will get your information on file. Okay, I'm seeing a lot of thank yous to our presenters. I want to add my thanks, certainly for this introduction, because it's certainly not the all of it, to this introduction to this very important area of law. I'm not going to call you experts, but esteemed presenters, we'll go with that. Okay.
So
Thank you to both of you.
I would like to take a quick minute, and I want to thank Alyssa, because I knew that this needed to be done, but this is not my area of law, and I couldn't think of who would I ask, and Alyssa has been amazing. I would say the weight of this has fallen on her as far as the content and the legal knowledge, and I just cannot thank Alyssa enough for stepping in and really making this a great seminar. So thank you.
Oh, of course. It was my pleasure. Thank you.
Thank you to both of you. And with that, I'll simply say that Mickaboo's next presentation during this holiday weekend is at 1:00. It's going to be yours truly, taking you on a QVC style journey through some of our online fundraising auction offerings, followed by an interview with Judy Irving of the Wild Parrots of Telegraph Hill fame. So hopefully we'll see some of you there this afternoon, and we've got more interesting presentations for you tomorrow as well. And with that, thank you to everybody for your time and attention. Look forward to seeing you again.
Thank you so much.
Thank you.
Thank you.